Good afternoon, everyone. Welcome to Senate Education. It's Thursday, January 13th, 1:36. Apologies for the delay in getting started. We are going to spend today looking at a draft bill for the church and state issues that we've talked about. We're then going to have a little testimony. This is something that I suspect we'll continue our work on throughout the session, and just have to recognize and understand that some witnesses are really very much on the ground right now dealing with the pandemic and could not be available. We are then going to shift and look at another draft bill having to do with teacher retention. We'll then wrap up the day by having a conversation, committee conversation, a little bit reflecting on the testimony we heard yesterday around, again, what's happening on the ground with schools. Is there a direction that this committee would like to move in at this point? Recognizing, I would also say that the final guidance document has yet to be sent by the Agency of Education. And I did have a conversation or an email exchange with Secretary French today that he will come into the committee as soon as that document is done, whether it's tomorrow or Tuesday, take us through that document so that we can better understand some of the ideas that he's putting forward in partnership with the Department of Health. So for now, why don't we leave it there? Unless I see any immediate questions, we will go to our Legislative Council.
Okay. Good afternoon. For the record, Jim Damer, that's Council. We are going to go through this draft, which if I can share the screen. Daphne, can I share the screen?
Yep, just 1 second.
And Jim, while you're doing that, I'll also let those who may be watching know that Senator Terenzini has a family priority that he is addressing today and will not be in committee.
Okay, so here is it's 219. Here it is. Okay, so here's the bill, and you will be quite familiar with this bill because this is the same bill that you were developing last session, and it is in the place that it was at the end of last session, so it hasn't really changed. And I'll take you through the first part of this bill on the use of public tuition, and then Beth will take you through the section dealing with dual enrollment. So
if I may, Jim, just to tee it up for anybody who might just first be joining us, this Mr. Demaray and Ms. St. James gave us a presentation. I'm sorry, is it St. James? Anyhow, I don't see everyone on my screen. Last week, outlining the issue that we're dealing with right now in the state as it relates to public dollars going to religious institutions. There are going to, I suspect, be multiple ideas to get to this, to get some kind of resolution. We also recognized last week there are a number of court cases out there that also need to be resolved. But so this is just, I would say, an idea based on some of the conversations we had last year. And this could be turned into a committee bill, or we could keep it as is, but this is just really a starting point. So with that, Jim, I'll turn it back to you.
Okay, so we have some findings and purpose here, and I won't read these, but it goes through the Vermont Constitution and talks about the compelled support clause in the Chittenden Town case that we've been discussing. In that case, again, stands for the proposition that in order to use public tuition at independent religious schools, there have to be adequate safeguards against the use of those funds for religious worship or instruction. And then subsection C says that the purpose of section 2, which we're about to come on to, is to define adequate safeguards that a school district must employ to ensure that public tuition is not used for those purposes. So section 2 is amending current statute, and current statute here is section 828 of Title 16, and the changes in sub A are immaterial. Well, just formatting changes. But B here talks about the requirements when school districts pay tuition. So it reads, a school district shall not pay tuition to a school or program regardless of religious status or affiliation. So this applies to all independent schools, not just ones that are religious, unless it receives a certification from that school or program that none of the tuition for which payment is requested has been or will be used to support religious instruction or worship or the propagation of religious views. And the school or program has adopted and implemented policies and procedures to comply with all federal and state anti-discrimination laws applicable to public schools and makes reasonable efforts to enforce these policies and procedures. The certification requirement shall not apply to public schools that receive public tuition. It would back up, so it would not require a school or program to comply with the anti-discrimination laws from which it is exempt from compliance under a labor statute. So what this is saying here is you will recall from testimony, I believe, that under the Supreme Court's Guadalupe case, a religious organization is permitted to discriminate against its employees if those employees perform a ministerial function, which is a very vaguely defined term. So if the person is in a ministerial function at a religious organization or school, there are not protections, for example, against age discrimination or disability discrimination, etc., for that category of employees, so it's ministerial employees. What this section says is that under Vermont law, under the labor laws, there is a provision that says that that religious organizations are allowed to give preference to persons of the same religion or denomination, yeah, so basically what this section of Vermont law says is that a religious organization can discriminate if it's to promote the religious principles for which it is established or maintained. So under Vermont law, there's a narrow exception saying if it's kind of part of your principles to discriminate, then it's okay in terms of employment law. So that seems to suggest to me a more limited exception than is the case under Guadalupe. Guadalupe is very broad. If you're in this ministerial category, there's no protection. Under Vermont law, you are protected more, except for these narrow categories where that discrimination of an employee is based upon the religious principles of the church or school. I'm not sure that's clear, but let me pause there in case there are questions.
I don't quite, didn't quite follow 100%. I apologize. So would you just mind repeating then, Jim, what exactly that section you're planning, what
Yeah.
it does.
Yeah, so that's my fault for not explaining it well enough.
No, it's
Apologies.
not.
Under Vermont law, forget about the Supreme Court case for now. Under
Okay.
Vermont law, religious schools, religious organizations are allowed some degree of employment discrimination. And that degree,
Give us an example.
well, let me just read the section because I'm trying to summarize it. Maybe I should just read it to you.
Okay.
Is that okay?
Sure.
So this is labor law, section 21 VSA 495 subsection E. And it says, the provisions of this section prohibiting discrimination on the basis of sexual orientation and gender shall not be construed to prohibit or prevent any religious or denominational institution or organization or any organization operated for charitable or educational purposes that is operated, supervised, or controlled by or in connection with a religious organization from giving preference to persons of the same religion or denomination, or from taking any action with respect to matters of employment that is calculated by the organization to promote the religious principles for which it is established or maintained.
What year was that, Jim? What year was that?
I have to go into the green. No, I have to look that up for you. Can I come back to you on that point?
Absolutely. Yeah, I was just, it seems to me that maybe that's something that would warrant changing.
Perhaps it's a policy matter. My goal here, what this provision does in your bill, is it preserves this exemption, because this exemption is already in Vermont law. So I didn't feel I could go just take it away, right? So
I understand. No, I appreciate that. Yeah.
So therefore, that's why it's there in your bill.
Senator Hooker and then Senator Pursley.
So I'm confused as to what it's preserving, and
Yep. It's preserving, it allows religious organizations to give preference to persons of the same religion or denomination.
Okay.
Okay.
So that's something that's already in law.
Yeah, already in Vermont law. And two, it allows them to take any action with respect to matters of employment that is calculated to promote the religious principles for which it is established. So that employment piece there, I'm not sure what it really means because it's not really specific in terms of what types of discrimination it might engage in.
Okay, so am I getting this correctly then? If someone is hired by a school, the religious school has the right to give preference to someone, say it's a Catholic school, someone who's Catholic.
Yep.
You can't say you're discriminating against the Protestant who applied or the Buddhist who applied, or okay. And if it's found later on that this person who was hired doesn't fit with what is expected of a Catholic, then that person can be let go for.
If that person is in a ministerial function. So for example, the case, I have to go back to the Guadalupe case for you. In that case, for example, there's a lawsuit by two ex-employees of a religious organization, school, I believe, and they were both brought claims that they were fired based on age discrimination, one case of that, and one case of disability discrimination. And the Supreme Court held that because these individuals performed ministerial functions, so they taught religion, for example, in their classes, they brought the kids to church services, because they had a ministerial role, therefore the church is exempt from anti-discrimination laws in employment. So therefore it could discriminate against those ex-employees based upon age or based upon disability status. So that's what that case did. What the Vermont law, I think, is saying is more narrow than that. I think what Vermont law is saying is if the discrimination in terms of employment promotes your religious principles, then it's okay. So, for example, in my mind, I might be wrong.
It's okay to discriminate.
Yeah. So in my mind, I might be wrong with this, but as I read this, what my mind goes to is you could see that possibly somebody could be let go because they, I don't know, maybe, yeah. So maybe to your point, Senator Hooker, the employee did not promote the religious principles of the organization well enough, and they're fired for that. Okay, that would be allowed under this statute. But I'm not sure if this statute will allow you to fire somebody based upon their age or based upon their disability. I can't see a religious principle that.
But Guadalupe would.
Yes, it would. Yeah. So you might have a constitutional issue with this bill language, be Guadalupe. That's a whole separate topic we need to talk about. But in terms of the Vermont law, I think it's more narrow. I read it to be more narrow than Guadalupe is. And so, again, you might want to go back and look at that law again and reform it. But the reason it's in your bill is it exists under Vermont law. And I just didn't want to change that for now.
Yep, thank you. Senator Pursley.
Yeah.
Thank you. Yeah, I think the question of when that section E got inserted into subsection 495 would be interesting, and how it relates to that Supreme Court Guadalupe decision.
Yep, it would be. And if you give me 1 second, I can pull it up for you right now. Just take me a second to go find it.
I wonder if was the legislature thinking of Guadalupe when they put that in there, or not, because this is specifically to sexual orientation and gender identity, doesn't mention other discrimination, which makes me think that it wasn't about Guadalupe, because Guadalupe wasn't about those things. So it is interesting why this was put in here, but basically it would allow any religious organization to fire somebody based on sexual orientation. All they would have to do is calculate that the work that person was doing was promoting their religious principles, which seems like a pretty low bar for the organization, just to say, hey, yeah, we're calculating that person as doing janitorial services in the building is promoting our religious principles, and so therefore we're allowed to fire them for their sexual orientation. Seems like it would be legal with this.
So I'm looking at this. This was last amended in 2017. It doesn't give me the full. I'm online. I'm sorry. I have to go into the hard copy books to find. This is my area, so I have to check with Damien.
Yeah, sure.
I'm not sure when this was done, but the last time this was amended was in 2017, and I think Guadalupe came after that. I'm quite sure it came out after that. So if that's true, it can't be in response to Guadalupe because it happened before.
Right.
Yeah, it kind of seems like I was just going to say, since it's only talking about sexual orientation and gender identity, it seems like it was done for some other reason, maybe another court case around religious organizations and those two issues in discrimination.
I don't have the history to it, I'm afraid.
But you can come back to us tomorrow with that.
I can. Yep.
Great. Okay.
Yep.
Senator Perslick, do you have any additional questions right now?
No, thank you.
Okay. So I just want to go back to the definition of ministerial role. So Senator Perslick brought up the point. Yeah, I mean, it's so broad. Has a state tried to define that?
It's not really a state issue, I think. It's really a federal law. I think it's a case law issue. I think it's coming.
Okay.
I think it's developed by the. I don't know enough about that either because it's not my area. Again, it's
No,
Damien's
sure.
area, so I don't want
Okay.
to speak too far on this.
Okay,
Um,
fair. Yeah, no, we'll let you loop back to Damien on those 2 questions.
Okay.
that'd be Later. Senator
Okay.
Persnick.
I would think that we would want to think about, in this bill, if we're going to move forward on 219, that we're saying that if the 219 wouldn't apply, the requirement that the schools say that they're not discriminating unless they're complying with this 21 VSA 495E, that we'd want to change 21 VSA 49E because the E just says calculated by the organization to promote the religious principles, but the Guadalupe is ministerial exemption. And like Jim just said, the Vermont law here is much more broad as it relates to sexual orientation and gender identity. And I think we could maybe update this to say that the religious organization has to show that it's a ministerial position, even though that is also broad, but it's not as broad as promote the religious principles. If that makes sense.
Yeah, putting it on them to demonstrate. I like that. Yeah. All right, Jim, if you would just keep a list of drafting things as we start to, get
Yep.
some of these questions answered.
Yep.
That'd be great.
Yep.
Senator Persnick, a follow-up? No, okay.
Let me go back to.
No, please go ahead, Jim.
Okay, let's go back to the bill again because we
Yeah.
didn't get through it that far.
Yeah.
Yes. Okay, so we're just talking about B here. So again, what B says is the certification requirements shall not require a school program to comply with anti-discrimination laws from which it is exempt under that section. So that's the context here again. And then C says shall not prohibit the use of public tuition for instruction designed to provide an overview of religious history and teachings, provided the instruction set designed to and does not support religious instruction or worship, etc. So this is designed to allow courses, for example, of an overview of religion, that kind of course, without following a follow of this certification. And then 2 says the certification can be modified in accordance with these exceptions that we just went through. And then D says that a school district that is requested to pay tuition under this section shall not make that payment if, in the reasonable belief of its school board, the school or program is not in compliance with the certification under B, even if it has received the certification, and that the agency will assist the school districts in making this determination if asked. And the decision by the school board can be appealed to the state board, and the state board's decision would be final. Then we go on to the section 3, which amends the public
Let's just
accommodations.
pause there for a moment. I see
Sure.
that Senator Lyons has her hand up, and
Yep.
Senator Persnick, your hand is still up. Do you have additional questions? No, okay. Senator
But-
Lyons.
You're right. I'm going back to B on the top of page 4, and what is included in 21 VSA 495E? What are we exempt, what are we asking the school or program to do? I
So
mean, currently exempt, so what is it that we're unexempting them? Uh-oh. Mr. Chair, I'm going to have to,
Okay, Senator Chittenden.
Maybe to put Senator Lyons' question on the shelf until she comes back. Can I go back to page 3, line 10 and 11?
sure.
Sure.
I'll read it, and it's a different point, but I think with Senator Lyons' phone going off, it makes a good time to bring up. So I'm not saying I support adding this word, but I remember some discussions from last year. This statement says, none of the tuition for which payment is requested has been or will be used to support religious instruction or worship or the propagation of religious views. I remember a distinction Chair Campion made last year about how support could be indirectly helping a school if you are paying for the math and English professors so that then they can provide more of the religious instruction elsewhere. Does it make any sense from a legal perspective to add a directly support religious instruction or worship to recognize? I just think with support, one could make a broad argument that any public monies going to that school are supporting any religious components of that education. So I'm wondering if direct support might make greater clarity of our intent.
Or you could get rid of support altogether and just say has been or will be used for.
I could see that making sense too, but I'm not a lawyer, so.
Yeah, I think yeah, I think either could work. I think it's a little bit more concise to say for, but
Yeah, that sounds okay to me, as long as it sounds okay to Senator Shindon and others. Okay.
That does make sense, because that's implying it's for the religious instruction, which is more direct rather than broadly support.
okay,
Okay.
so going, oh, sorry, are there more hands?
I don't see any. Senator Lyons is trading stocks right now, so we'll let her do that. We'll come back to that.
So this next section here, we've gone to the heart of it already, right? We have an amendment to the public accommodation section. I'm not sure where this came from, frankly. I'm not sure it's necessary either. We'll go through it. So the current language in statute is basically talking about the solemnization of marriage, and allows religious organizations not to solemnize marriage if it's against their religious principles. So this, this basically allows that type of exemption for them. It's current law. And then this part was added last time. I'm not sure why. It says this subsection shall not be construed to permit a religious school that receives public tuition funds to deny services, accommodations, advantages, etc., because of their membership in one or more protected categories listed under subsection A, including sexual orientation or gender. The reason why this doesn't make sense to me, I'm not sure why we have it, but is this part here is talking about marriage. It's talking about an exemption for churches not to have to marry people if it's against their religious principles. It's nothing to do with schools. So this is like
Right.
this section here designed to give clarity that the above section doesn't allow discrimination not otherwise permitted. Is unnecessary to me, but obviously somebody requested this and it's here, so I'll just note the fact.
I don't recall that being requested, but perhaps others do. Senator Chittenden, Senator Perchlik.
Maybe Senator Perchik was about to make this point, but might this have to do with ensuring that religious schools that don't want to honor a marriage that they would otherwise disagree with any privileges that might be assigned to it? Is that what this language is trying to accomplish? I'm not saying I would support keeping it, but I know my spouse, who's a teacher, has to inform both parents when they, even if they're separated or otherwise. Is this like some sort of regulation around the interactions with the parents and the marriages they might be in, and giving some shelter to the religious schools? Not shelter, but did I make that point at all clear? Senator Perchik probably has a better point to make.
You're just a new guy here. My point was, it seems like this is pretty close to the language we would want to clarify that 21 VSA 495E, which is employment law, but we wouldn't, as far as it relates to the school receiving public money, we don't want these schools that have this right to discriminate, like under the Supreme Court decision or under this other part of the statute, to deny a student the educational services of that school based on sexual orientation, for example. And that's what I think this language is doing. I agree with Jim. It's weird that it's in this section, but it seems like, could it be that it's just in the wrong place? But what we were trying to do.
Jim, do you want to jump
I,
in?
I just don't know the answer. I'm sorry. I just know.
Yeah,
I'm not sure how this came about. I mean, the language isn't harmful. I mean, it's basically saying what's, I think, already in effect.
Right.
But I don't
why
think it's-
raise it and why point? Yeah,
it doesn't seem helpful either. So I'm not sure why it's there.
right. Senator Persley?
Jim, what would you think if we were to add that language under that 21 VSA 495E, saying that, you know, that language that allows discrimination basically should not be construed to allow discrimination of students' entry into the school.
Yep.
It would be worded a little different.
Yeah, I'm not sure that you need it there either, because the other provision is just about employment. So it seems to be, it's like, again, it wouldn't hurt, but I'm not sure it's going to help. I think they,
How about we put it in here in S219, saying, notwithstanding 495E, we're clarifying that they don't have the right to discriminate against students because of sexual orientation or gender identity.
yeah, I think what we should do is maybe have Damien come in as a witness, if that's okay, because he's the person that is the expert on Guadalupe and on the section of law, because he covers labor issues. So I think it'd be helpful to get his perspective to you.
Yeah, we'll have Daphne schedule him tomorrow afternoon while we're still on this. But if it would be great before Damien comes in, if you could just get us a couple of those other answers around the history of, you know, when this was put, some of this language was put in, et cetera.
Yeah, he'll have that because he's going
Okay.
to, it's
Okay.
his title again, so he's gonna have the history.
Got it, got it, got it.
I'll send him an email after we're done laying out all the questions, so he's fully
That would be
prepared to
great.
come in and talk about them. Yeah, yeah.
Senator Lyons, we'll go back to Senator Lyons' question.
Right, it was on the top of page 4. I was just looking for clarification of what 21 VSA 495E includes.
Okay, that's what we've been talking about. Yep.
Oh,
So
good.
you were away a bit for that.
I was, I had to take
It's
that
fine,
call.
absolutely. No, please, go ahead, Jim.
So that section is a labor law provision
Mhm.
that allows religious organizations to give, it's a Vermont law, right? Allows religious organizations to give preference to persons of the same religion or denomination, okay, in terms of hiring. Okay. Or it can take any action with respect to matters of employment that is calculated by the organization to promote its religious principles.
Okay.
So
Yeah.
I'm not quite sure what that means, and that's why Damien might be able to help us a bit tomorrow.
But it's for employment.
Employment.
Okay, so in
Yeah.
other words, then what we're saying is if by some chance there were a group of students or a student who was looking for some kind of special educational experience and there was only one person around who could do it, even part-time, you could hire that secular person rather than having someone within the religious organization provide the instruction. I don't know how it would be applied there, but that would be neat to know.
Well, I'm sure that the schools can hire secular people. That's be their choice, right?
Yeah, okay.
Yeah.
But this would
Even-
demand that they do that, right?
No, this is
No?
demand anything. It gives them an exemption from a claim of discrimination. So it gives them the ability to, for example, hire employees who are Catholic and not be sued because they weren't hiring Muslims or people of other faiths, right? So there's some permitted discrimination allowed here because it's in line with their religious principles.
Got it.
How that works in the employment context,
I'm
not
trying to
quite-
figure this all out, where it fits too.
Yeah, no, it's complex, absolutely. And
Yeah.
hopefully Jim and Damien will both be, and I suspect Ms. St. James will also all be here tomorrow, hopefully to help pull some of this apart. Because you're right, there's a level of complexity between labor and religious rights, education policy. Senator Perslick.
I was just gonna say for Senator Lyons is what I was saying, I think, which is way it's important that the beginning of that E subsection says, the provisions of the section prohibiting discrimination on the basis of sexual orientation and gender identity. It just mentions those two protected classes. It then goes on to what Jim read. So it seems like they're calling out saying, for the basis of sexual orientation and gender identity, you're allowed to discriminate. That's the way I read that subsection.
And one of the things we're trying to get our head around, Senator Lyons, is when was that put in?
Right.
And what's a little bit of the history of that statute. And so hopefully Damien will be able to give us some clarification around that tomorrow.
Yeah, I think just to that point though, the beginning language here says the provisions of this section prohibiting discrimination on the basis of sexual orientation or gender identity shall not be construed to prohibit. So they're basically saying all this stuff above this subsection E here that prohibits discrimination on the basis of gender and sexual identity, that's all in place. You can't do that in the employment context, but notwithstanding that you can't do that, you can do these other things.
Right.
You can discriminate in the employment context. So I think this is really going to the employment question. It's just saying that other stuff that we were prohibiting is still prohibited, but despite that, you can do these other things. But again, let's have Damien take you through it. He'll be a better presenter than me.
Not necessarily. You do a great job.
On this topic, at least. Yeah.
Okay. Other questions for Mr. Desmarais at this point?
We're only halfway through the bill, just to
Right.
say.
I just at this point, any other questions? No. Okay. Great.
Okay, so we are done with the part I was going to talk about. So we've been through all of this stuff here. All this is about the tuition piece and certification and no discrimination. Now we move on to the topic of dual enrollment. So I'm going to turn this over to Beth. And Beth, if you want to take over the screen, you can, or I can just do it for you.
Good afternoon, Beth St. James, Ledge Counsel for the record. I think, let's see if we can do it with you doing the screen, and if it gets awkward, I'll just take over. How's that?
Okay, yep.
So sections 4, and 5, then the last section is the effective date. So sections 4 and 5 address the dual enrollment program. Section 4 are findings and purposes, and this is session law right now. And it basically, the findings give a little background on the dual enrollment program itself and why there are proposed changes to the current statute. So I won't read these verbatim, but I'll just kind of try and summarize them. So under Title 16 in the courses of study chapter, which is chapter 23, there's a subchapter that addresses flexible pathways to secondary school completion. And within that subchapter is the dual enrollment program. So the state will pay for high school students who have not graduated yet and are past, I believe, 10th grade, or I think 10th grade or 10th or 11th or 12th grade, and they haven't graduated, to take up to 2 classes that count for both high school and college credit. So that's a big benefit. The benefit is only available to students in public schools and approved independent schools on public tuition. So on its face, students are eligible for this benefit, whether it's a secular or a religious school, as long as the program, as long as the student is in that school on public tuition. So if a student is at a approved independent school on private tuition, on parents' dime, they would not be eligible for the dual enrollment program. They would not be eligible to have the state pay for them to take up to 2 classes at an approved post-secondary educational institution. And so, Jim, if you could just move it down just a little bit. So this section D finding is going over what Jim has already gone over in regards to Chittenden and paying public tuition to a school with a religious mission. We could keep going maybe onto the next page there. So schools, we've talked about this. We talked about this last week, and Jim mentioned it in his presentation. We know that a publicly available benefit cannot, which the dual enrollment program is, cannot be denied to a school with a religious mission based solely on the status of that school being religious. So let's see, if you could keep going there. Okay. Likewise, under the Vermont Constitution, a school district may not deny participation in the dual enrollment program solely because the students attend a school with a religious mission. So again, status. If the school has adequate safeguards as to the use of public funding, then the school is eligible for public tuition, and students who attend the school on public tuition would therefore be eligible to participate in the dual enrollment program. And then subsection F is just the purpose is to ensure that school districts do not deny participation in the dual enrollment program to students who attend a school with a religious mission based on the school's religious status. So there is some case law that came out. There was a case that involved students who are attending Rice Memorial in South Burlington who wanted to enroll in the dual enrollment program, and they were denied because they were attending a religious school. So read in conjunction with the previous sections that are applying those safeguards, the amendments in section 5 to the dual enrollment program are meant to make it clear that as long as those safeguards are in place and public tuition is being paid to that religious school, then students in religious schools do qualify for the dual enrollment program. So the creation, this is the dual enrollment program appears in section 944. This is just a little preamble to help orient us. Program creation. There is created a statewide dual enrollment program to be a potential component of a student's flexible pathway. The program shall include college courses offered on the campus of an accredited post-secondary institution and college courses offered by an accredited post-secondary institution on the campus of a secondary school. The program may include online college courses or components. And then the statute goes into who is eligible. And so you have to be a Vermont resident who's completed grade 10. So it's completed grade 10, but has not received a high school diploma. And they are enrolled in, and then there's 2 sections here that we are not included in this bill, which are basically you're at a public school or a career tech center, or you're at a designated school. So those schools who are school districts who do not maintain their own schools and tuition their students out, but they have designated specific schools that their students that they're paying tuition to. It's not just open for any school. Those students qualify for the dual enrollment program. And then subdivision AI3, and it is amended to say an approved independent school in Vermont and added including school that is secular or has a religious mission, to which the student's district of residence pays publicly funded tuition on behalf of the student. So again, clarifying that folks who are attending a religious school do qualify for the dual enrollment program. This bill does not currently touch the public funding of tuition. So the public funds would still, the student would have to still be on public funds at this independently approved school. And then K, subsection K, is added to read schools with a religious status. A school district shall not deny dual enrollment benefits under this section solely on the basis of a school's religious status.
So those last couple of sections, we're doing this because there are questions out there in the community that in districts as to whether or not they can and should be doing this, right? I mean, we're trying to clarify something that we might not like seeing happen, but for whatever reason, we're being pushed to clarify it. I don't know if Beth, if that's you or Jim.
So I didn't draft this. I can certainly take a stab at it, but since Jim drafted it and worked with you all last session on this,
Jim,
I certainly don't want to
take a stab at it?
overstep.
Yeah, sure. So back for the record, Jim Demery, that's counsel. So why are we changing this? Changing it because there has been, it seems to be a lack of clarity in the school districts on this topic. And the Rice case was interesting because the record in the Rice case was that the school district or school districts, I'm not sure which, denied dual enrollment because it was a religious school. So I think there's a lack of kind of recognition out there. And this whole dual enrollment topic is a subset of the topic we just talked about. So it's because the school districts have not been paying public tuition to these schools because of their religious status. It's because they have not been paying tuition that therefore the knock-on effect is that these students aren't entitled to dual enrollment because you have to be in public tuition to get that benefit. So this is all designed really to clarify that both secular and religious schools, if you're on public tuition, count toward dual enrollment, and to clarify that school districts can't deny that based solely on the basis of a school's status.
Senator Perslick.
And Jim, can you remind me how the dual enrollment money flows? Isn't the money flow from the state to the college where they're enrolling for the college classes, right?
Correct.
So the money doesn't go to the Rice Memorial, for example, in that case. Okay,
Good
that's
reminder.
but well, but your point was right now there are no students going to Rice Memorial that are paid with public dollars. Because
There might be, I mean, over time in the last 20 years since Chittenden, I understand, I thought this wasn't true, but I've been told differently that some school districts have been paying public tuition to religious schools without the safeguards in place. So there might be some students on public tuition at Rice or other places. Not sure.
okay. So, but as far as we're clarifying that, as far as dual enrollment, even though the money's not coming from the sending town for that student, the money's coming from the state and going right to the college.
Correct. And the sending town district gets an ADM credit for that student.
But no, I thought well, no, that's early college. They don't get the.
Correct.
Yeah.
Yeah.
Okay, thank you.
Oh, well, maybe I'm wrong with that. I should check back on, I'm speaking without checking my facts. Look at 944 to make sure they do get ADM credit.
It came up in the people waiting task force. I don't know if Cheryl remembers that. Like, I don't know if it's just dual enrollment or early college, because early college, they're gone. They're away at the college.
Right.
Not kind of, but maybe dual enrollment because enrolled in both. And there was a question about whether they should get credit, at least partial credit for those students. I think it's the early college, not dual enrollment.
I think you're right. I don't see it. It's not jumping out at me. So
Senator Hooker.
I'm just curious to know if there's any complication if the student enrolls in a dual enrollment program in a religious college.
Would you repeat that, Senator Hooker?
Would there be any complication to this if the student enrolled in a religious college?
Like St. Mike's?
St. Mike's.
You mean use dual enrollment dollars to St. Mike's?
Going to St. Mike's, yeah.
I don't think that is prohibited now. I believe post-secondary schools
As long
are
as they're
eligible.
accredited.
Yeah, has to be accredited post-secondary institution in Vermont. Yeah, so as long as it's a approved, accredited school, private, they can use it for that purpose.
Okay. Thanks.
So if you're a high school student in the St. Michael's College area, they have a dual enrollment class that you want to take, chemistry, whatever. Those dollars can go to St. Mike's for that class.
If they're accredited and approved.
They're accredited, yeah.
Yeah.
Okay.
I think they have to agree to it too. The colleges can't be forced
Sure,
into it. Yeah.
sure. Senator Persick.
Sorry, one more thing. You mentioned the Chittenden case, but wasn't there a specific case on that Rice Memorial, like a Vermont Supreme Court, or was it a lower court case?
Second Circuit.
So is there a value in mentioning that in here, or do we not mention it because it's not a state Supreme Court case? Or it's still like working its way through the process?
Go ahead, Jim.
I was gonna say, I think it's not final yet. I think it's a decision. I'm not sure what stage it was, Beth, but I think it was like an injunction.
It was an so it wasn't a case that declared public funds shall be used at religious, students at a religious approved independent school shall be eligible for the dual enrollment program. It was someone who was attending Rice, wanted to sign up for the dual enrollment program and was denied because they were at a religious school. And then they said, hey, by the time this winds its way through the courts, I'm going to be long gone and I don't get to take advantage of this dual enrollment program. So the Second Circuit said, they did an analysis. I'm happy to go into it if you want me to. I don't think you need me to. And said, we're going to say, while this course figures itself out, go ahead, you can enroll.
Mm-hmm. All right, that helps. Thanks.
And as if I may, as a part of that, the helpful thing to us here is the court had to make certain findings about and do certain analysis on probability of success and the analysis of the claims. So that's why this is helpful to us in this discussion, is that there was some analysis. It wasn't just a finalized across the board decision applicable to all cases. Jim, do you disagree with any of that?
No,
Please.
that's right. Yeah. Oh, yeah.
So thank you for the walkthrough. Lots to be done. We'll have Daphne schedule one or both of you back tomorrow with Damian Leonard. We'll continue along this theme. In the meantime, we will shift to start hearing witnesses. We have one that was available today, Mill Moore. I believe the others will be coming in together. That would be our two prospect and NEA. I think they're all going to try to get to they haven't already, some consensus. But for now, let's shift, Mr. Moore.
Good afternoon, Senator Campion and committee members.
Good afternoon. If you would be so kind as to introduce yourself and tell us your thoughts on where things stand with the direction that we're heading in.
Happy to do so. I'm Mill Moore, Executive Director of the Vermont Independent Schools Association. And thank you for inviting me to speak today on S219. This is a bill that addresses some really important matters concerning the use of public funds to support Vermont students' education in independent religious schools. A little bit of statistical stuff to put things in context. Vermont currently has 17 approved religious schools, and they enroll 1,895 students in the current academic year. That was as of the October census. And then the most recent enrollment data as far as tuitioning goes is for the previous academic year. That's from the Agency of Education. That shows 14 students receiving tuition attending religious schools last year. So 14 out of 1,895 total enrollment in the religious schools, and 14 also out of approximately 2,500 being tuitioned to any independent school. So very small numbers relative to the overall universe of tuitioning and religious school enrollments.
Senator Hooker.
Thank you, Mr. Moore, for being here. Are those 14 students allowed per order of the school boards from the districts that they come from? I mean, how do they get tuition?
Yes, the tuition has to be approved by their district school board.
Okay, thank you.
Senator Chittenden.
Mr. Moore, would you also know how many students in total are tuitioning right now in the whole state, not just the 14 that are going to these religious schools?
Yes, it's about 2,500, Senator Chittenden. And a similar number are being tuitioned to public schools. So overall, tuitioning is about 5,000.
Senator Hooker.
And with that, just to follow on with the idea of dual enrollment, do you have numbers of students in the independent schools that are engaged in dual enrollment?
Sorry, I have not had a chance to investigate that, Senator. I got notice yesterday at about this time of today's hearing, and I did a lot of scrambling to prepare with what
Enough of the
have.
excuses, okay? Let's, come on. So I'm not exactly, I'm not giving people a month in advance. I apologize.
All right,
No,
shall
Mr.
I-
Moore, seriously, no, I appreciate you being here, and I realize that.
And I welcome the opportunity, Senator, and I'll be happy to do follow-up research if
Sure,
necessary.
I
So shall I go ahead?
Yes, please, thank you.
Okay, so there are three objectives in the bill's statement of purpose, and I'm going to address each one in turn. First, there's the proposal to ensure compliance with the U.S. and Vermont constitutions with respect to paying tuition to religious schools. And there's the specific requirement in the Vermont Constitution or in the interpretation of the Vermont Constitution, that there be adequate safeguards to ensure that funds are not used for religious purposes. My association agrees with this objective. We think that the relevant holdings of the U.S. Supreme Court and the Vermont Supreme Court are clear and well understood. Additionally, we think it's going to be very helpful for legislation to clarify the responsibilities that school districts have to take care of that adequate safeguards requirement. The current procedures, as I've observed them across the state, are somewhat inconsistent. It's all new for school boards to be doing this. They're kind of making things up as they go along because they've got no guidance. I think we would like to see some consistency, and it's especially important for a school that is enrolling students from multiple districts so that they don't have to answer different questions from different districts. Second off, the second objective is that the bill is going to prohibit payment of public funds to any qualified independent school, whether religious or secular, if it's not complying with the non-discrimination laws of the United States or of the state of Vermont. the Vermont Independent Schools Association Executive Committee recently affirmed that this association does not support the use of public funds in any school with discriminatory enrollment or hiring policies. So we are squarely in line with what is being proposed in S 219 on that principle and on that objective. On the third objective, the bill would clarify the circumstances in which a school district shall make dual enrollment services available, dual enrollment money actually, to students attending religious schools. And I'm going to say a little bit more about this, a little more detail, because I think it's rather unfortunate that dual enrollment has become so closely linked to questions about tuitioning to religious schools. There is no reason for that linkage. And that linkage has caused unnecessary denial of public benefits to several Vermont high school students. Dual enrollment for religious schools was on this committee's agenda 8 years ago. And I was active at the time as an executive director of the Vermont Independent Schools Association. And I testified and appeared. And with my encouragement, the committee also invited in Professor Peter Teachout from Vermont Law School. And I have provided to your committee assistant a transcript of his testimony, his written testimony, among the materials that I have sent along. I also have provided the text of a memo I wrote to the committee chair at the time, Senator Baruth, and a position paper, a follow-up position paper from our association on the topic as well. Now, Professor Teachout said, he concluded that neither the US Constitution nor the Vermont Constitution required excluding students attending religious schools from dual enrollment support. There's no church versus state concern here because the money does not go to the religious institution.
If I may, Mr. Moore, yeah, just on that note, I think I'm one of the ones that keeps bringing this concern up. And I would just say what my concern always is, if a religious institution were to say to its students, let's say you have a small religious school, 50 students, we are not going to offer the history class, we're not going to offer the blah, blah, blah class. You're going to take that class at, through dual enrollment dollars. That's where I feel it gets fuzzy, if you will, because you're basically saying to the chemistry teacher, your services are no longer needed. That salary is then, goes back into the coffers to perhaps then it mixes with religion, etc. I remember being in rooms with Professor Teachout on this issue in years past, and I think he and I agree that is the it's unlikely, it'd be hard to prove, that kind of thing. But I just want to be on the record that I am one of the ones that continues to raise that concern. But with that, please.
I agree completely that it's a somewhat fuzzy area. I'm not sure that, I've never heard of it happening, that a school required a student to take a dual enrollment class in lieu of the school offering it a course on its own. That would be quite an extraordinary thing, I think. But in any event, students can't be excluded because dual enrollment is part of students' constitutional entitlement to a publicly supported education. It's available to all Vermont resident students. So anyway, a few years ago, and I haven't had a chance to research this, but I think it was maybe in the 2017 session. No, it would have been either 16 or 18. What happened was a correction to the dual enrollment language passed both houses, both bodies, and went into a miscellaneous ed bill along with a bunch of other unrelated topics on which the House and the Senate did not agree. So the bill went to a conference committee, and the conference committee was unable to agree at the end of the session, and so the bill died. The entire bill died. Even though both bodies endorsed the corrections to the dual enrollment language. So what I would really recommend is that this committee look back to find that language and see if you can still agree with it and move forward that way. That accomplishes the need, I think, of separating dual enrollment from the question of religious tuition, and will short circuit or ease anyway your consideration, because there's language in there that once upon a time everybody thought was fine.
I saw Ms. St. James noting that, so appreciate you going back and taking a look.
That concludes my testimony, and I'll be happy to discuss any details.
Thank you, Mr. Moore. Any questions for Mr. Moore? Seeing none, really appreciate you coming in, Mill, and in all seriousness, apologize for the last minuteness of the request. We will work to, we'll continue to have folks in. I suspect you'll be tracking this issue as well, and we'll likely, we're going to pick it up again next week. Well, a little bit tomorrow, and then more fully with other witnesses next week. So if you, as you are following it, if you find the need, please reach out to us and we'll get you on the calendar.
Thank you. Yes, I will do that. Can I just ask you what is next on the agenda? I saw your agenda earlier where you had all of my public education colleagues ahead of me. Are they going to be testifying today, or is that going to come later?
No, the agenda has been updated. They will
Okay.
come next. They're going to come next week. We are going to shift now, and of course, you're more than welcome to stay to a different conversation on teacher education and retention in future hiring.
Very well. Thank you.
Yeah, thank you. Committee and Ms. St. James, I know you have a 3:30 hard stop, but we'll just take, if it's all right with everyone, we'll just take 5 minutes and come a little over 5 minutes. We'll come back at 2:50 and then we'll go until 3:30.